Hello, I'm John Vanderloo, editor of International Employment Lawyer, and thank you for joining today's webinar on dealing with harassment in the working environment. Allegations of harassment, bullying, and sexual misconduct have affected countless well-known employers since the MeToo movement began exposing unacceptable workplace behaviour back in 2017. Today, we are joined by three leading lawyers from Morgan Lewis to discuss how employers should respond when allegations of inappropriate behaviour are raised and the risk associated when getting that response goes wrong. However, before we get started, there are a few housekeeping points to cover. First, please use the online question tool to post any questions you might have for our panel, and I will share them with the speakers during the Q&A session at the end of the presentation. Second, if you have any audio-visual problems during the presentation, please let us know by using the online question tool, and a member of our team will be on hand to support you. And finally, just to note, today's session is being recorded. We will share a copy of the recording via email and on IEL in the coming days. All that being said, it's my pleasure to hand over the reins to Louise Skinner in London, who will begin the discussion. Louise?
Thank you so much, John, and thanks very much to everybody for joining us today. We're very happy to be here, and obviously this is an enormously important topic, and I think particularly at the current moment in time when so many people have been out of the workplace for the better part of 18 months, and they're now starting to come together again at work, and we can expect, I think, to see some real challenges there from a harassment perspective, both in terms of sexual harassment, but I think also as people become accustomed to new ways of working, hybrid working, and just getting used to being around others again, particularly when they've got health concerns within the workplace in a way that they're just not accustomed to having to deal with. So I think this is a really important topic for employers to be getting to grips with now as they start to bring people back. So just to do some introductions first, before we get into the meat of it. My name's Louise Skinner. I'm a partner in the Labour and Employment team at Morgan Lewis in London. We have the leading employment law practice in the United States, but also a broad international network, and we work very closely with our colleagues around the world on many different cutting-edge employment law issues. So within my own practice, I do a lot of work on investigations and litigation involving allegations of harassment, discrimination, whistleblowing, and I also do a lot of work in the diversity, equity and inclusion space, including conducting culture audits and advising on global pay equity matters. I'm delighted to be joined by two of the world's leading experts in this field. My partner is Jocelyn Catino from our Washington DC office, and Leslie Corner, who leads our practice in China. So I'm going to come on in a moment to ask them to introduce themselves and their practices, and to provide an initial overview of the landscape relating to harassment in their regions. But I just want to, first of all, touch on the position at a broad level in the UK at the moment. And what we've decided to do for today's session, we've highlighted some really key topics around harassment, around conducting investigations, allowing people to speak up, and we're going to work through the points in a conversational style, hopefully to make it as interesting as possible. And obviously, if you have questions, we're very happy to take those at the end, but do fire them through. So just to touch on the position over here, obviously the COVID pandemic has had a significant impact in relation to working practices, and as I mentioned, I think this is going to be a big topic for us as we all come back. But the UK government has also shifted the dial just in the last couple of weeks in relation to workplace harassment. So they conducted a consultation in 2019. Now, because of the pandemic taking over, they've only just been able to respond to that consultation. But what they've said is that they are going to introduce a statutory duty which requires employers to prevent sexual harassment. So that means employers will have to be able to demonstrate that they have taken steps, proactive, positive steps to prevent harassment concerning. So rather than just being needing to defend claims that an individual brings, they will have to demonstrate upfront that they have taken appropriate steps. So that will be quite a significant change, and we're waiting to see exactly what that's going to look like. The other thing they've said they will do is introduce explicit protections from third-party harassment. So they will look at protecting people when there are customers or other third parties, contractors who are in the workplace, making sure that they have a right of recourse in that respect as well. And the final point that they are considering is extending time limits for bringing harassment and discrimination claims. Currently in the UK, there is a 3-month time limit, and it's felt that in certain circumstances, particularly where somebody has experienced something that's very personal to them, it may just take longer before they're in a position to bring a claim in that respect. So they're looking at extending the time limit to 6 months. So I think this is certainly an area where there is a lot of scrutiny at the moment. Employers should absolutely be reviewing their own internal frameworks for preventing and managing cases of harassment, and really considering what more they can do at this stage. So Jocelyn, can I come to you next for an introduction of your practice and also the overview in the US at the moment?
Absolutely. Thank you, Louise. And hi, everyone. It's great to be here with you. As Louise said, my name is Jocelyn Catino. I am also a partner in Morgan Lewis's labor and employment practice in the Washington, D.C. office. I advise and counsel clients on a wide range of day-to-day employment issues and workplace culture issues as well. I also conduct internal investigations and defend clients in all aspects of litigation. And in terms of an overview of where we are in the US, I would say that since 2017, around the MeToo movement, of course, views on harassment and tolerance of harassment in the workplace have changed drastically. Employers have increasingly done a better job of investigating and addressing claims, as opposed to past practices of sweeping things under the rug, not taking prompt and corrective action, and just letting things linger, while often it was the complainant who was moved out of the organization. So the attention to those issues since then certainly has not slowed down. From my perspective, one of the questions at the outset of the MeToo movement was, how long would this movement last? And it has not slowed down, in my view. Many state and local laws have also made efforts to prohibit companies from attempting to sweep things under the rug by limiting confidentiality provisions in settlements of cases involving harassment claims. And in that sense, we can't any longer tell people who feel that they've been victims of harassment that they cannot speak about the terms and conditions of their employment if they enter into a settlement agreement with the company. So I think we've continued to move in the right direction in terms of ensuring that companies are paying attention, addressing harassment concerns, and also conducting training into anti-harassment policies, which is also required by some states and localities. So that's generally the overview here. A lot of nuances, of course, within that.
Fantastic. Leslie, come to you.
Sure, thank you, and it's a pleasure to be here with you all. My name is Leslie Lagorner, as Louise said, and I sit in our China offices and split my time between Beijing and Shanghai. I am a US trained lawyer. I started out with litigation investigations and all aspects of employment, and I moved out to China just over 15 years ago, and I basically do the same thing and specialize in Chinese employment law, as well as helping clients with internal investigations, largely harassment discrimination investigations around Asia. And so my practice is quite broad and deals with many different jurisdictions, but at the end of the day, it's a best practice standard, largely driven by US standards, because that is where most of the best practices have originated in terms of identifying and weeding out harassment and discrimination in the workplace. In terms of the current trends, it really is quite different across Asia. The pandemic has obviously affected everyone in the region, less so in China, where we've been back to work since March of last year, largely. But discrimination and harassment, while very robust laws are in place, very few claims are actually brought here in China, and very few are actually litigated. So there's a scarcity of actual law in the books where there's been cases, but the law again is quite strong. Where we see far more discrimination harassment cases, and it's largely power harassment, sexual harassment, is in Japan, and we also see a very robust amount of claims in Korea for sexual harassment in particular, and then also in India, again, for sexual harassment. So it really does vary across the region, but generally speaking, in Hong Kong, Singapore, China, the number of claims are quite small compared to what you see in Europe and in the US. So that's the landscape.
Okay, no, that's fantastic. Thank you. Well, moving on then, I think, to our first discussion point. What do we mean by harassment, and how can we recognise it within each workplace? And I think certainly I can start from a UK perspective, because we have a well-developed statutory framework when it comes to harassment, but our legislation protects against harassment on the basis of protected characteristics. So our harassment law is linked to race, it's linked to sex, to age, to disability, sexual orientation, and other protected characteristics under our Equality Act. But there is no straightforward, unattached claim of bullying that we can make on its own under UK employment law, which is quite an interesting dynamic, because of course, from a cultural perspective, it's really important to identify and look to prevent harassment of any type, not just harassment relating to protected characteristics. So I think there is a balance for employers to strike there in terms of trying to make sure that they engender the right culture across the board. That said, of course, part of this is also protecting people from harassment related to their individual and personal characteristics. And obviously, you know, as we've discussed and as Jocelyn set out in relation to the MeToo movement, sexual harassment does tend to be a very significant factor within many workplaces. And unfortunately, you know, we do see that, you know, all the time, despite the fact that this has become a much bigger issue and has had much more publicity over recent years. And I think racial harassment, unfortunately, as well, is still very much at the fore. It was really unfortunate, disgraceful after the Euros finals here in the UK very recently, the racial abuse and harassment that was suffered by the players immediately after the final. And it's just so disappointing to see that happening. But what we are seeing is employers stepping up in those circumstances and making a stand. And from publicly available information, it would appear that certain people who were identified as having participated in that bullying behaviour after the Euros final were dismissed from their employment. So if they were associated with having made those comments, even though this wasn't something that took place in the workplace at all, where an employer has connected their employee to this kind of behaviour, they're not willing to condone it. And I think that's quite an interesting development. So I think although it's incredibly unfortunate and disappointing that this type of behaviour goes on, we're definitely seeing here more employers making a stand when these sorts of issues come up. But in terms of the sorts of harassment that we see in the workplace, it can be lots of different things. It can be bullying people, it can be excluding them, it can be nitpicking in the way that they're doing their work, it can be physical, inappropriate touching, it can be trying to persuade somebody to go for drinks, being, you know, putting them under pressure, putting them in uncomfortable situations, calling names, it can be all sorts of things. And the important thing about our framework is harassment is based on the perception of the individual receiving that behaviour as opposed to what the perpetrator intends. So somebody might not intend to offend, but actually it's about the environment that they create on the basis of their behaviour and the comments that they make and so on. So that's an important distinction here. And I think finally, the point I would make is in terms of when is it workplace harassment, the definition is broad and it's evolved through a number of different cases, but it's not just what happens when you're physically sitting in the building at work. It could be a work function after work when people have gone out for drinks. It could be something that happens on a business trip. Even if it's after hours, there can still be a connection to the workplace if you have colleagues together. And I think that's something that employers need to be vigilant about and make sure that people are fully trained on. So certainly, I think it's something that we're seeing lots of employers try to pin down and identify what amounts to harassment in our workplace, what is the culture that we want to encourage. But that obviously has to be set against the statutory framework and the protections that employees have. So that's the UK position. Jocelyn, it'd be great to get your perspective on what we mean by harassment in the US and how employers can identify it there.
Yeah, absolutely. You know, I'd say it's quite similar, Louise, in the U.S. Similarly here, employees are protected against harassment on the basis of protected characteristics, same in terms of race, gender, national origin, and things of that nature. Although some states have also implemented anti-bullying laws that don't necessarily have to be tied to a protected characteristic. So some states and some cities, some localities do have rules that protect against bullying in the workplace, even when it's not tied to one of those things. I think although the standard for what constitutes harassment is very high here and often pretty difficult to meet, less egregious forms of bullying can certainly set the stage for more serious forms of harassment to occur if they go unchecked. So I think that's where we notice the biggest problems really start getting set in motion when there are lower levels of bullying and things happening in the workplace that may not be as serious as what we might constitute as legally actionable harassment. But allowing employees to get away with that type of behavior is really what ultimately leads to people feeling empowered to engage in more serious types of misconduct. And so we really see, in terms of our advice for employers and our clients, a lot of it focuses beyond just what is legally actionable, right? Because we want to avoid that and be proactive in the first place. And again, in terms of the trend and focusing more on those issues here in the US, I think, we've done a much better job lately, I say we, meaning employers, companies, of trying to take action on less egregious forms of bad behavior before we get to the point where we're having to defend a legal claim or, defend ourselves in the media when something goes public. So I think it's becoming more clear that there is a pathway and we need to jump in earlier on the pathway as opposed to waiting until we get to a certain point. And certainly a lot of our advice is focused on nipping things in the bud earlier on and making sure there's a record of taking action against things that might be less egregious and not as bad as what we think of, your traditional form of harassment under the law. But just things that are lower levels of misconduct. You mentioned asking someone out for a drink in a way that makes them feel uncomfortable. I mean, it's little things like that where, we want to take action and have a conversation. Maybe it's not discipline, right? Maybe it was sincere ask that was rejected, but still making it clear that you don't know how the other person is going to feel about that question, and so it's best not to ask and not to, put coworkers in the position where they feel like they have to say no, and it could be awkward for them.
Yeah, no. And just I think to touch on a point that you made, the framework across the US, because obviously you have different laws from state to state, you have federal law, you have even city by city law. And are you finding more these days that employers are setting the stall themselves? So they're implementing their own policy, which perhaps the baseline might, be a higher threshold compared to what the local law actually says, but because they're saying this is the standard of behavior that we expect, and this is what we will treat as harassment, even if there is a patchwork of laws that applies across all the places that they employ people.
Absolutely, Louise. And it's one thing to just have a work environment where there's no illegal conduct, but frankly, that work environment could still be quite unpleasant for a lot of people because it's a very high bar. So we also want to make sure everyone feels comfortable and safe working in the environment, whether or not people are engaging in illegal conduct. Hopefully they're not, and we've nipped that in the bud. But also just to make people feel comfortable lends to productivity, it decreases attrition, it saves money, it makes people happier in the workplace. So the bar has to be much higher than the law in terms of the type of workplace culture that we want to cultivate. And also, it's helpful too, like for national or even international employers that want to have a set of policies that are, up to par everywhere, to accommodate some of those states that have so many more protected characteristics. They just necessarily have to be broader. So for example, while under the federal law, Title VII, the number of protected characteristics is quite small. There's only 5. In DC, there are more than 20 protected characteristics, and the Department of Employment Services motto is "We bet you're protected." So there's just a wide range of things that are protected here, like family obligations, political affiliation, obviously that's a big one here, and things of that nature. And so to have a policy that's robust enough to apply nationally, it really just has to be much broader than federal law, and really broader than even states that have that number of protected characteristics. We want to discourage bad behavior of any kind, whether it's based on a protected characteristic or not, right? So that makes it necessarily much broader than the law. So I think I 100% agree with that.
No, that's interesting.
I had a little trouble hearing you.
Sorry, Leslie, is it the same in Asia, would you say, in terms of trying to find a baseline, or because the laws are so different, is it just very difficult to do that?
So I think, you know, of course, the baseline across Asia is so different. Can you hear me okay, or is there an echo? You can, okay. The baseline across Asia is so different. We have much fewer protected categories in some of the jurisdictions, and then in other jurisdictions there are many, but they may not be enforced. And in many of the Asian jurisdictions we have some homogeneity, and so because of that, people, if they are in the minority, they don't feel like they will be protected, they're afraid of retaliation, so they don't bring claims. So I think when we talk about what do we mean by harassment and how can you recognize it, I think a lot of it depends on, you know, it has to be a strong foundation in the policy and the commitment to respect in the workplace and diversity and inclusion. So when you do have people who may be, whether it's of a protected category or they're different in some way, and it may not even be that people realize that they are different, and they say things, that it really does need to be embodied in the policies. And so, you know, a lot of people don't look at the law to protect them. They look at the internal workings of the company. Do you have a good complaint mechanism, and do people have faith in that mechanism? And if they're not using it, then that's one of the ways you can recognize harassment in the workplace, is it probably does exist, but no one's using that complaint mechanism because they're afraid. And that's very common. I will say during COVID, though, we've seen people speak up across jurisdictions in Thailand and in Japan, and even in China, in ways that we hadn't seen before in numbers. And so people, I think, felt more bold because they're not in the workplace surrounded by all of their colleagues. And we'll see what happens when people come back to work. Another way I think that companies can recognize harassment in the workplace is if there's high turnover. Very often when we see that problematic boss, for example, or that problematic colleague, everyone around that person will start to disappear. They will start to leave and seek transfers, or they will resign. And so that creates huge issues for the company, obviously. And that is a way to get some insight. And then, you know, I think companies need to also train their employees not to just look at what the law requires, but to, again, to understand what the policies require, and that respect in the workplace has to be a value, but everyone has to live by it. And so you can't have pockets, again, of high turnover and issues because you've got a bully, or you've got someone who's a bigot, or someone else who's just not treating people with respect. So that's, you know, so harassment means so many different things across Asia, but there are ways to weed it out, you know, across the organization.
Fantastic, thank you. It's complex. It's certainly not an easy topic, and I think our next subject on this, should employers take a zero tolerance stance when it comes to harassment? I think that's also a very complex question. I think when we look at it from a UK perspective, certainly one positive that has come from the MeToo movement is that people who were getting away with it before aren't so much now. So sometimes there would be people within organizations who everyone knew was a bully, or everyone knew that they would, you know, potentially look to harass new employees coming in. and they turned a blind eye because it was an important person, they were a rainmaker, they were protected for whatever reason. I think people got away with that kind of behaviour much more. I think now there is a movement towards zero tolerance to that kind of pervasive behaviour. So no matter who somebody is and their status within the organisation, more employers are ready to take action when they identify that kind of behaviour. So I think that's one aspect of it. But taking the flip side around the zero tolerance position, it's tricky for us in the UK because there is a real sense of fairness embedded within our legislation, and so we have to follow quite robust procedures if we are making a decision on whether somebody has committed misconduct, which would include harassment, and we have to investigate, we have to consider all of the evidence on both sides, we have to give somebody a fair hearing. And it may well be that there are cases where somebody has done something wrong and they've made somebody feel bad, feel bullied. But whether that actually is something that would permit us to dismiss that person under the UK legal framework is another question. It won't always be the case. And I think that can be then quite hard for an employer who's trying to say, we take a zero tolerance approach when there are any allegations of harassment. It's not that simple from a legal risk and legal process perspective. So that's one issue we have to deal with here. And I think finally, there is also the argument that if you have a completely zero tolerance approach, not only is it difficult for people to learn from mistakes because they don't get a second chance, and obviously it will depend on the severity of the act as to whether it is appropriate to give them a second chance. But the risk is, I think, it stops people speaking up because they think, that's it, that person's going to be out, and I'm not sure what they did was that bad. I think it's something that really I should be making my employer aware of, but I'm so worried about what the consequences will be, I'm not going to say anything in the first place. So I think although a lot of employers say we take a zero tolerance stance, actually there's quite a lot of nuance to that. So those are the sorts of things that we're dealing with here. Leslie, maybe I can come to you in terms of taking a zero tolerance stance in Asia and what that looks like.
So I think, I agree with a lot of what you've said, and I think in a perfect world that every company would have a zero tolerance policy, but there are always exceptions, there's always nuances, as you noted, and so it requires striking a balance and reviewing the totality of the circumstances in any particular situation. So while we have under Chinese law, for example, in mainland China, a requirement, just like you were mentioning in the UK, statutory requirement for employers to prevent and prohibit sexual harassment in the workplace, the law doesn't actually provide the legal consequence if employers don't do that. So it's left to how do employers prevent harassment in the workplace, how do they stop it, and can they take a zero tolerance stance? And the issue here is it is so difficult to terminate. Even when we have clear-cut cases, if we don't have someone come and testify, so we've had rape cases where an employee has raped a hotel staff, and we find out about that. We go to terminate the employee, and lo and behold, we don't have a valid statement. The individual who was raped is in a different location, or she's afraid to come. She's terrified, or she's just traumatized. And so without that statement, without that testimony, we don't win. And so employers can't really take that zero tolerance stance. They have to figure out other ways to discipline and to basically create a non-hostile working environment for their employees when the evidence simply doesn't add up. So it becomes very difficult to say we have a zero tolerance policy, given the issues, in delivering on that, particularly from a disciplinary perspective. And that's across many of the countries. Hong Kong and Singapore, it's far easier because you can terminate more easily. But Japan, Korea, Indonesia, and China, very, very difficult, as an example.
I think that's really interesting. And Jocelyn, I'd love to come to you on this because my sense from working, with many US headquartered clients is the zero tolerance approach is probably strongest in the US, where there is a much more permissive employment framework, employment at will, and it is easier to take action. But what's your perspective on that?
Yeah, that's it. That's exactly right. I mean, it's considerably different here because in 49 states and DC, there's one state, lone state, where there's no at-will employment. But in most states, employment is at will, meaning people can be fired at any time for any reason or no reason at all. And unless there's a collective bargaining agreement where a union is in place, there's really no appeal procedures or even guidelines to follow when it comes to terminating employees. So enforcing a zero tolerance policy in the US becomes a lot easier because there really is no standard when it comes to what reasons you need to have or evidence or things of that nature, or even whether a complete investigation has been conducted. In fact, we've seen claims from terminated employees where they argue that they've been fired without a thorough investigation, and there's no obligation to do any investigation really at all before terminating someone. So there's no claim that results from that. Now, there does need to be an investigation into the harassment claim itself, and so that's no substitute. Just firing someone isn't a substitute for doing a full investigation. But in terms of the firing, the act of firing itself, that doesn't carry with it an obligation to do any investigation. Of course, there can't be an illegal reason at play, but really any other reason for terminating is fair game. I think one thing that is difficult with respect to enforcing a zero tolerance policy in the US is that harassment claims here have both an objective component and a subjective component. So objectively, some forms of harassment are considered so severe that no employee should be subjected to them no matter where they work. So for example, racial epithets, right? It only has to happen one time. It's bad enough for all of us to know it's offensive. In other cases, the harassment has to be severe and pervasive, meaning it permeates the work environment to such an extent where no reasonable person could be expected to work there and be productive. So on the flip side of the objective component, in some cases, the work environment and sensitivities of an employee may be part of the analysis. So the extreme example being if an employee works in a strip club, for example, obviously the expectations and sensitivities around that are going to be much different than someone working in a church. So the totality of the circumstances have to be considered on a case-by-case basis. Certainly any form of harassment that's objectively unacceptable shouldn't be tolerated. But outside of that, it's difficult to say there's going to be a zero tolerance because we have to think about what are the circumstances, what are the sensitivities, and put that in perspective before saying like just having this claim or just having this, one instance is going to be, you're immediately out the door without looking into it further.
Okay, so that makes sense. And I think that ties in to one of the topics we come on to in relation to conducting investigations and what we should be looking for. But before we get to that, I think it would be good just to touch on how to create an effective speak up culture within businesses, because I think obviously with complaints of harassment, so often people are scared, they're concerned, they don't want to put their head above the parapet to raise something that happens to them. Often it is something more senior, whether it's a direct line manager or somebody else who's, the tree in terms of management responsibility and influence within the organization, and that can make it incredibly daunting for somebody to put their hand up and say that they feel they're being harassed. And so, Jocelyn, perhaps I can come to you. It'd be really interesting to hear from a US perspective, where obviously there has been a huge amount of activity over the last couple of years. How have you seen the dial move in terms of creating an effective speak up culture within businesses?
Yeah, I mean, I think first and foremost, it's creating an environment where employees feel comfortable speaking out and like they won't be subject to any sort of retaliation for doing so. And having policies in place that clearly prohibit retaliation for speaking out or raising concerns of harassment or discrimination is, primary, right? It's baseline necessity to have in place. But on top of that, it's making sure there are multiple avenues for reporting concerns. So for example, if an employee has a problem with their manager, we can't expect that employee to tell the manager directly that they have that problem. There has to be some avenue outside of the manager to go and report those concerns. But then on top of that, that avenue has to be effective. Right? People are going to want to report things if they don't think anything is going to happen. And we hear that a lot when we do these workplace culture assessments and listen to feedback about why people haven't come forward and why they haven't complained. We hear, well, nothing's going to happen anyway. No one ever gets in trouble. The company never does anything, right? And things of that nature. So even having those avenues in place isn't enough alone. There also has to be a commitment to taking action when complaints come in and doing so quickly and effectively. That's all super important. We also recommend too, especially in large organizations, having an anonymous hotline so that if people don't feel comfortable reporting even to a person, they can bring up a complaint anonymously. And a lot of times the question is, well, what can we do with anonymous complaints if we don't know who's making it? If a complaint is just doesn't have enough information to really take action, then sometimes there may not be as much to be done. But I would say 8 times out of 10, maybe more, there's at least enough information there to have a starting point for looking into something and digging deeper and trying to figure out where it's coming from. And even if there isn't enough information, tracking those complaints is important, because if complaints continue to come in that relate to a certain department, for example, then we want to know that, right? We want to know that there's a repeated, I think you talked about this a bit earlier, we want to know that there's a repeated problem that needs to be addressed. Bystander training is really important. That's something that I think we really didn't start to see as much until post MeToo movement here in the US. But really making sure that people who observe inappropriate conduct also feel comfortable reporting that conduct, and not just reporting the conduct, but also stepping in and saying something in that moment. Because, we find that our studies have shown that it's not as effective just for the victim of the conduct or the recipient of the inappropriate comment or whatever it may be, to speak out to the person, even if they are comfortable saying directly to that person, look, I don't like that, that's not cool with me. Sometimes that gets put off as like, oh, you're too sensitive. But when someone else says, hey man, that's not an okay thing to say, like you shouldn't be saying that, that has a much bigger impact on, the person engaging in that activity. So empowering people to be that person who steps in and says, this isn't okay, is really important. It really helps, not just with respect to feedback culture, but making sure people know that they're going to be called out if something happens. It may not be a manager or an HR person, it could just be a colleague, but someone's going to call them out for it.
Yeah, those are great. And also, anything or say it's different in Asia, just within the framework?
So I agree with everything that Jocelyn has just said. I think the real key needs to be that people trust the system, that if they make a complaint, that the company will do something. And I think the hardest thing about that, and Jocelyn, you touched on this, is yes, the company should be doing something, but you can't always share that you've done something. And so there's the perception that nothing was done if someone isn't fired. Like if they see someone disappear, then everyone knows, even if you haven't, you don't broadcast it. But when they don't see the change, or they don't see the discipline, or they don't see something has happened, that's what makes it really challenging to engender the trust in that complaint management system. And so I think, finding ways to let employees know that issues were resolved because someone came forward and used the system, the internal complaint system, used the hotline, or sent something to HR. That's really important, and particularly in Asian cultures where people don't speak out as much. They have to be able to trust that their voice will be heard and not retaliated against. So that becomes one of the most important things for companies in order to create that effective speak up culture.
Yeah, no, absolutely. And I think then moving on to our next topic, which I think very much feeds into exactly what you've said about trust, about knowing that action is going to be taken, that this is taken seriously. I think the way that allegations are investigated is hugely important. It gives employees a sense of safety if they feel that it's done well, if their confidence and anonymity is maintained. I think that's one of the things that we see most, is people saying, I'm too scared to give evidence, I'm too scared to tell you what happened to me because I'm so worried about what the repercussions might be. And so creating an environment where people feel safe to give that feedback so that the investigation can continue, I think incredibly important. Now, you probably won't be surprised, in the UK we do have quite a prescriptive framework in terms of how an investigative process should be carried out. You know, we need to ensure that it's fair and reasonable, so we will speak to witnesses, we'll look at any documentary evidence. We need to make sure that any decision makers are suitably independent from the issue in question, that they aren't seen to have some kind of bias for or against either the perpetrator or the victim. And you know, we need to think about what consequences are overall. So even if we find we can't prove that harassment has taken place, we still need to manage the fallout. If we've got people who are supposed to carry on working alongside each other, we need to think of ways at the end of an investigation to deal with that dynamic. So you know, there are lots of different steps, I think, that come into conducting a reasonable and robust investigation. I think, Leslie, one point I wanted to pick up with you, and this is something that we come up with a lot in harassment cases, is sometimes there's just no clear evidence either way. You know, often these are instances where perhaps you've had two people in a room together and the victim, the complainant, says that something happened that they were really uncomfortable with, or that they were called a name that they didn't like, or something was said. But often it's one person's word against another. There's not always an email trail to show what's gone on. There's not always another witness there. And so, you know, what would you say, what's your advice to employers where there isn't hard evidence in an investigation?
Those are the most difficult. I think there's always something that an employer can look at. And I think, you know, oftentimes it's having investigators who have a sense, who can really assess credibility. And there will always be something that someone's story just doesn't add up, some part of it. And so I think of it as picking apart every single thing that the victim has said and everything that the you know, alleged harasser has said, and figuring out ways to, you know, compare, contrast, and figure out what makes sense and what doesn't. And generally, you can find that the weight of the credibility leans towards one of them. Very often I found, you know, particularly when it relates to drinking, as you both mentioned, it's every jurisdiction, you know, that people will feel very bad afterwards, the next morning. And that's when we get a lot of complaints, particularly in China, after there's been some event involving alcohol. And so both parties are embarrassed, both parties cannot believe what happened, and so one of them will allege something untoward. Very often, though, we'll be able to pick apart, and it might show that it's completely consensual, or it might show that there really was something in the way that someone's, you know, carried themselves, if we can get video footage, or the way that or something about the way that they've carried themselves. Again, it relates to the credibility. And so we'll generally be able to find something that helps us lean one way or the other. And it may be that you really can't make a determination that there has been harassment or bullying, but there's certainly something to be able to counsel on about your respect in the workplace policies, your anti-discrimination policies, because you have someone who has alleged something and you can't get to the truth of the matter. So clearly something has happened that you can at least counsel. It doesn't have to be.
Yeah, okay, no, that makes good sense. And Jocelyn, another tricky question that I think comes up quite a lot in investigations is around vexatious complaints. So where, you know, perhaps there's been a performance management process ongoing and an employee is quite upset about that. They feel it's unfair. They feel that they've been, you know, unfairly singled out. And so they put in a harassment complaint. They say that they feel they're being bullied. Possibly they say they feel that they're being discriminated against or sexually harassed. And there's a perception that they've done that either just to string out the process, to keep their pay and benefits going for as long as possible, or because they have a personal vendetta against that individual. You know, do you have any advice for employers who are grappling with those sorts of potentially vexatious complaints?
Yeah, absolutely. And that's documentation, right? The key is having documentation of performance issues, any issues of misconduct, noting those things. If there's a written warning process or, you know, something like that, in effect, it's important to make sure those types of written warnings are issued and put in a record, right? Because what the Supreme Court in the U.S. has said is that you can't use a complaint as a shield to guard against legitimate performance actions. And so, you know, if someone who suspects there might be termination lurking tries to make a complaint and then says, well, you know, my termination was based on this complaint I made. If there's documentation in place to show, like, no, these performance issues had been happening, we had spoken to this employee about it, or, you know, this incident was documented, then you can show that those issues predate any complaint that was raised. And, you know, that breaks the causal connection, so to speak, but in a retaliation claim. So having strong documentation really is kind of the best defense in a retaliation case where someone's just trying to get out of trouble by bringing a claim. One thing that I thought of just on the previous question about when the investigation doesn't have a lot of concrete evidence, I think one thing that I found over the years is that when someone is inclined to be a harasser, they're usually not harassing just one person, right? Which is the importance of making sure we pay attention to if multiple complaints are being lodged against one person. You know, there may be one complaint that can't be proven because it was a one-on-one scenario, no one else was there. But if you have 3 or 4 people coming forward saying they had, you know, similar scenarios, then it's a bit easier to say, okay, there's an issue here because multiple people are reporting a very similar experience. So we look out for that too. And, you know, often it may be necessary to, for example, if there's a manager who's being accused of harassment, chat with a couple other people who report to that manager, see if they've observed anything. You know, we found that sometimes we have those conversations, especially in the workplace culture context, and people say like, oh yeah, everybody knows he's creepy or something like that, where you then find out that this was a thing, right? And people knew and no one came forward. So often like digging into it a bit more, even if in one scenario there's not a lot of evidence, can lead to more evidence. So that's going backwards a bit, but on the retaliation question, it's definitely the documentation is important.
Yeah, no, that's a great point. And one final point. The investigation. Quite often we have an employer comes and says our witnesses will only speak to us if we can guarantee them anonymity. So they will not give us any information unless we can promise that their name will never be disclosed. Now in the UK that's quite tricky because we have very broad disclosure, discovery obligations if it comes to litigation. But also because of our overarching principles of fairness, we do need to consider fairness on both sides. And so if somebody's being accused of something very serious, there's an argument that they should have visibility over all of the evidence that's being provided and that they should be able to test the credibility of that. And so generally speaking, we would advise against an employer guaranteeing anonymity. We would try and reassure the individual that there will not be retaliation, that we will take every step we possibly can to protect them from any kind of retaliation. But actually guaranteeing anonymity of a witness is difficult. What's the position in the US? Is that similar?
Very similar, and in fact, I'd say it's often impossible to make that guarantee, especially in harassment cases, because if you have to speak with an accused about an incident and say that happened at a restaurant on Thursday, right? There's no way we can guarantee that anyone there will be anonymous, because that person is going to know who else was there. So we take a very similar approach of trying to guarantee confidentiality to the extent possible, but making it clear that in many scenarios it's not possible to really have a 100% guarantee as to confidentiality, and not just because someone can identify other witnesses and things of that nature, but because it's also necessary to confront someone about an incident using the information that's available, right? We see that a lot too, like in performance-related scenarios. Right, it's one thing to say, hey, your writing could be stronger or something like that. It's another thing to say, here's this memo, here's where the things could have been beefed up. So having something, a concrete scenario to relate a conversation to makes a big difference. And so, yeah, it's absolutely cannot be guaranteed. We also have the same approach with making sure the anti-retaliation policy is clear, making sure it's enforced, making sure it's communicated well. And at that point, if someone is still reluctant to participate, really, in the US, we take the position that participating in a company investigation is an expectation of anyone's job. And it's an expectation that an employer can uphold, and not participating or providing information that will allow an employer to take prompt and corrective action can itself lead to corrective action. So, it's a tough scenario, because obviously the only reason the conversation's happening is because someone's uncomfortable and doesn't want to come forward. So it's always, it's a sensitive situation. You don't want to feel like you're forcing their hand. But the downside of not doing anything and then having the incident occur again with other people is a much, worst case scenario to be in.
Yeah, and I often that's something that we suggest the employer explain that actually this is about protecting others, and that's why your evidence is so valuable, because this is about the bigger picture.
Yeah.
No, absolutely. Okay, well, look, I'm conscious. I want to make sure we have a little bit of time for any questions at the end, but just coming on to sort of the final themes around what the risks are. Now, obviously, we're lawyers, so we are predominantly advising on legal risks, but actually, I think in our practice, all of us have started to look much more broadly. It's not just about the legal risks, the actual claims that can be brought in courts and tribunals, but it's also about business risks. It's about being an employer of choice. It's about being able to recruit and retain the best talent. It's PR. It's shareholders now are far more interested in what's going on culturally within an organisation. That will influence their choices around whether they invest. So there's a much bigger picture here, I think, in terms of what the potential repercussions are where people are behaving badly, where there is toxic culture, and where that's seen to be condoned. And I think, nowhere was that more visible than during the beginning of the MeToo movement, when, some really big industry names in the entertainment industry, they were toppling just amidst these complaints, and a lot of shock at what had gone on for so long. And so I guess, Jocelyn, just to come to you first, in terms of, from your experience, what do you see risks to be? Or what are the key examples of things playing out now that employers are particularly concerned about?
Yeah, for me, it's first and foremost the costs that are incurred as a result of attrition, right? Losing good employees because they're not comfortable, or they feel that nothing's being done to protect them, right? And not just losing employees, but also productivity, because people aren't as productive when they're in a workplace that's not positive for them. So there's a lot of costs that aren't readily apparent. And I think those are the things that we really started to think about following the MeToo movement, right? Because in a lot of cases, we saw some high producer who was lucrative for the company, who was engaging in bad behavior, who got a slap on the wrist because, oh, they're so important, they make so much money. But not recognizing that, okay, 5 people have left under that person's management, and how much did it cost you to try to recruit new talent, train them, invest in them, only to have them leave? So thinking about those other hidden costs to this type of behavior, I think, is something that has really come to the forefront of everyone's mind as we just start to think through these issues a lot differently.
Yeah, no, great point. Anything to add? Leslie?
Sorry, I'm having some technical issues. Hopefully you can hear me. I think, I echo what Jocelyn has said, particularly in Asia, as the talent war is quite strong. And so finding and retaining talent in many of the jurisdictions is so challenging for so many multinationals, that it is, that is a real aspect of not taking care of harassment or bullying in the workplace. And then the other aspect is the reputational risk. And people take to social media here much more, and particularly in China, much more than they do in other countries, and people will listen to it. So campaigns where if someone says, I've been terminated because I'm pregnant, and this company terminates a lot of pregnant women and doesn't allow, women, to actually, get married and have children, and they really are discriminatory, that's going to have a really negative impact. And it's going to be a social media campaign that's very difficult to manage. So that needs to be, thought about when companies are not responding promptly and effectively to complaints.
It's a great point. I think we've seen employees taking these things into their own hands so much more now, public letters, that kind of thing. So it really is important to get it right before it turns into that kind of scenario, which can be so damaging in all of the ways that we've talked about. Okay, John, I'm just going to call you back to see if there are any particular questions. I hope we've answered, or covered most of the key topics. I've certainly really enjoyed hearing about what's going on in other parts of the world, but if there are any specific questions we can pick up for the attendees, please let us know.
Thanks, Louise. Yeah, I'm pleased to say that almost all the questions we received from the audience have been answered in the presentation, which rarely happens. So congratulations on that. One slightly more nuanced question that I think some would appreciate clarification on is the line between an employer's responsibilities and the intrusion to private lives of individuals. So what kind of out of the office, non-employment related behaviour should an employer take action over, and which is really none of their business and they shouldn't touch and just allow people to live their private lives?
Yeah, no, it's a great question, and it's a really difficult line, and I think that's the case across all of the jurisdictions that we work within. We're certainly seeing regulators take much more interest in forms of personal misconduct, so harassment and so on. Regulators will want to know about that, and they will potentially investigate themselves. So I think we are absolutely seeing the line move in terms of personal types of conduct. But I do think there is a point, certainly in Europe, across which you cannot go. So, to give an example, if somebody is an employee and they are found to be having an extramarital affair, unless it's with another employee and it's causing problems, for example, from a conflict perspective, or it's creating issues for others working around them, then I don't really think that's the kind of issue that an employer should be getting involved in. I think we have to protect people's private lives. That's certainly the European Convention on Human Rights. That's a fundamental principle. And so I do think where there is no impact on others within the workplace, then that is a line that we shouldn't cross as employers. But where it's a personal issue, but it is having an impact on others, then I think it's important for an employer at least to consider whether there are steps that they should take. They may on balance decide that it is too intrusive. But I think more and more, to create an inclusive environment where people want to be, we do need to think about interpersonal behaviours, even if they aren't traditionally things that you think of as being wholly relevant to the workplace.
I think that's all we've got time for. My thanks to Louise, Justin, and Leslie for taking the time to be with us today, and for all of you who watched this session. Just a reminder that this webinar has been recorded, and we'll be sharing the recording online in the coming days. Thank you for joining us, and we hope to see you in another IEL webinar soon. Take care and goodbye.
Thank you for having us.